tons of questions.
Okay, wonderful. So, yeah, Auto Paychecks has made it a priority to educate and bring relevant and accurate information to business owners in our community. Thank you for trusting us to be your industry experts since 2013. My name is Manon. Many of you may recognize me from some of our webinar series. Over the past few years, we've had the opportunity to bring you a lot of content. If you ever missed any of those webinars, several of which Michael has done himself for us, you can visit our blog at autopaychecks.com and view anything from today. This recording will be posted there, and any of our previous webinars.
That's a video, right?
They will be.
Oh, really? Oh,
Yeah.
geez.
So anything will be posted there, and you can read it, or his presentation will be up there to read, or you can view it if you need to go back and revisit any of this information. A little bit more housekeeping. We ask that everybody please stay on mute so that we can clearly hear what Michael has to say. If you end up being, clicking off mute, I might try to monitor.
Hey, Manon, I don't know if you can hear me. This is Marika. You are muted.
How
Okay,
long have
you're
you been
better.
muted?
You're better.
Sorry about that. So, yeah, like I was saying, everybody is.
If you missed that last part, that was the key to employment law, so we're really nothing else to go over, so questions on that?
Yeah. If you have questions, please open up your chat window to submit them. Michael loves to have that feedback and to just know where all the questions are at these days. So please don't hesitate to open up that chat and submit those to us. I'll be monitoring and narrating those questions. So if you don't know Michael, he is a co-founder and partner at Bechtel and Santo, which is our law firm right downtown here. He publishes a quarterly newsletter that you can sign up for, and that's where a lot of our topics from today are going to be coming from, essentially, his summary of what's been going on in the world. I know we've talked to death, the HIFWA and our...
No, we're not talking more.
CARES and all of that.
It's so not going away.
But, yeah, with Polis, who declares that
Yeah, one way and...
it's over in Colorado, but then the...
Marijuana's legal. No, it's
Yeah,
not.
yeah.
So, yes, it
So
is. No, it's not.
we've got a lot of content just there, but he's also
No,
going to be
not
talking...
Make that an announcement. Sorry, go ahead.
Also be talking about the Nieto versus Clark's market and the decision on vacation payouts versus forfeiture, how OSHA was affected by COVID and the new log requirements, other recent Colorado court wage decisions regarding missed breaks and that paid 30-minute lunch break versus time off, and then your independent contractors, how it's even more complicated now to classify employee versus independent contractor, and then just more EEOC updated guidance for employees and employers regarding COVID-19 and the vaccine portion of it, which is a new complication. So.
Yeah, there's just a bunch going on right now, and so I appreciate the opportunity you guys put together the talk that we're able to go over these things. A lot of this you may say, well, there's seen this, seen that. Please ask questions. Some of the materials, you may say, well, HIPAA came out 8 months ago, or so I've got that. But ask questions, because as we're dealing with this on a day-to-day basis, that's where I find people are saying, okay, I got the umbrella of the law, I understand how it works, but this happened. What's that question? And so those are the things that I think are always helpful. And I'm sure if you've got a question, someone else has the same question. So we're going to start with court decisions and updates. And we're going to initially start with the Nieto decision. This is the vacation pay train that has been coming since 2004. And in essence, what happened in this case is that there was a vacation policy. I really should have said that there was a vacation agreement because of the way the case worked. And it said that if you are discharged for any reason or do not give proper notice, you will forfeit all earned vacation and pay benefits. And in the case, the way it was court identified it is that, they terminated her from employment, so it claimed that it didn't owe her for accrued vacation. She then, Ms. Nieto, filed a complaint for unpaid vacation leave, under the response, or in her complaint, and initially, Clark's Market argued that, hey, Colorado law says, as we'll see, that if things are under an agreement, we're gonna follow that agreement. And in fact, where this all began, it goes back to 2004, and I know this issue has come up repeatedly, but it all goes back to 2004 when the Colorado legislature changed the definition of wages to include vacation. And specifically, the law says vacation pay earned in accordance with the terms of any agreement would constitute wages. So that created the issue out there, which is, okay, if wages, once accrued and determinable, are the employees. Once an employee works 8 hours, and even if the employee slept the whole time they were on the job, they didn't perform anything, or was on Facebook the whole time watching the Olympics, doing whatever they were doing, that employee still needs to be paid for that 8 hours. It's not as though the organization can say, you didn't really do anything. Let's go back and we'll pay you at the minimum wage rate. Once it's earned and determinable, it's the employees. And the question became, what could you do with vacation? Could you have a use it or lose it system, which told employees, if you don't use vacation by the end of the year, we're going to take it away. Not pay it, but we're going to take it away. Could you have something that said, as the Clark's Market case identified, if you don't do X, Y, and Z at termination, if you don't give us sufficient notice, if we terminate you for cause, we could take it away. That became the big debate. And as will be seen in the decisions, the courts certainly struggled with it as well. Because initially, the district court, the first court to address the issue, basically said, look, Clark's Market controls vacation time. It doesn't have to give vacation time, and once it's even given, Clark's Market can control when it's paid out. So they don't owe this vacation upon termination. She then appealed that decision, Ms. Nieto then appealed that decision to the Colorado Court of Appeals. In that decision, the Court of Appeals said, no, Clark's Market doesn't owe it. Ms. Nieto, this is incorrect. You have to earn, vest, and it has to be determinable. The key language for the Court of Appeals became vest. And they said, look, people vest when you meet the conditions of an agreement. If I promise to pay your house for $1,000, which I'm not, but I don't get that money until I vest in the payment, until I paint the house. And so what the Court of Appeals said is, look, you didn't vest because there was a condition that still was outstanding. You still needed to give notice, or you still needed to go through termination without cause. And so because of that, the Court of Appeals dismissed her claim. Of course, she appealed to the Supreme Court back in April of 2020. And the Supreme Court's a great job if you can get it. It's a great job because they only have to take cases that they want to hear. They don't have to take every case. Wouldn't that be a great job? And frankly, I don't think there was ever a question they were going to take this case. There was another case right behind it referred to as Blount that had to do with a vacation policy. There were regulations with the Department of Labor issued right as Nieto was going on that were completely different than the Court of Appeals. And some have speculated that they did that simply so they could say, there's an issue of law here. We say one way, the Court of Appeals says another, Supreme Court, so you have to address it. Who knows why that happened, but however it is, this case was, ticketed for the Supreme Court, I think, pretty early, particularly once the initial court ruled. And so as you'll see, it clearly says whether the Colorado Wage Claim Act allows an employment agreement to forfeit an employee's accrued but unused vacation pay. The two key languages in there, two key phrases in there, employment agreement and unused vacation pay, and we'll get to particularly the second one in a second. The reason why that first phrase is so important is because it does not cover an employment policy, although I think if they ruled this way in employment agreement, they would rule this way in employment policy. But again, I'm not a Supreme Court justice, so maybe there's another argument out there that they'll treat them differently. Oral argument took place at the end of last year, and when the court issued their decision, they came out and said, look, there's no law that requires Colorado employees to receive vacation pay. Keep track, that's a very particular term of art, vacation pay. But once an employer does that, it's no less protected than the NRA wages. And so it cannot be forfeited upon termination. The court ruled that once an employee earns it and the amount is determined, so if you have in your agreement or perhaps in a policy, employee, you earn 2 hours a week, you earn 4 hours a month. Once they earn it, it's determined, once there's a specific amount, then the employer cannot take it away. The Supreme Court also looked back at the Court of Appeals decision. Remember, there were 2 decisions before the Supreme Court that said the Clark's Market didn't owe it. And the Supreme Court, with respect to the key language in the Court of Appeals decision, said, look, vesting, we don't see where that's required in the Colorado statute, so she doesn't have to vest. And said, look, to the extent that you have an agreement, Clark's Market, Ms. Nieto, we're going to say that agreement was inconsistent with the law, and because you can't have any agreement that is inconsistent with the law, we're going to say, Clark's Market, you owe Ms. Nieto her unpaid vacation.
We do have our first question.
Sure.
Is this the same for paid sick time now?
Brilliant question, because it leads into my next question, unaddressed issues, which is one of the issues that was not addressed is whether an employer can require an employee to forfeit other paid leaves that are not vacation leaves. So for example, if we got HIFWA, and we'll talk about HIFWA in a second, but HIFWA clearly states in the statute, both with respect to the sick leave and the public emergency leave, that it does not have to be paid upon termination. And so if you combine sick, particularly HIFWA, and vacation into a PTO policy, let's say, and you make it clear in that PTO policy that that it covers HIFWA, that it is intended to make sure that all the requirements of HIFWA are in there, I think it gives organizations a lot more discretion how they handle their paid time off policies. The Department of Labor has taken a stance for years that they have not looked to enforce PTO policies that combine sick and vacation, because they looked at it as very literal in the statute. If we go all the way back to the beginning, it says vacation pay earned, not paid leave earned, it says vacation pay. And so the Department of Labor has taken a very literal interpretation with that. And you look here in the issue on appeal, it was unused vacation pay. It was not unused PTO. So I think that gives organizations a much greater opportunity, ability, right, to structure their PTO policies so that you can take away a combined PTO and HIFWA upon termination. Is there a typo?
No.
Okay. I always think there's every time I print these, I missed a typo. Now, if you simply have a vacation policy, and let's say you have then a separate HIFWA policy and you have a separate other policy, then is there an argument, and you call your vacation policy Michael leave or something like that, happy leave, does that mean we don't have to pay it because it's not vacation leave? I think that's a little too much. That's a difficult argument. It's a form over substance argument. I think if you have a standalone vacation policy, if you call it strictly vacation, you're gonna run into a problem taking away leave. I think substantively, it has to combine the two leaves. I would make it very clear in the policy that it does combine. I mean, I'm encouraging organizations to have in there that it identifies that your paid time off, paid leave, whatever you wanna call it, that it covers HIFLA. So that's a big thing.
So do you need to, if your policy says that your PTO is a combination of vacation, sick, and HIFLA, do you need to determine percentages on that?
I don't think you do. I think there's an argument because it's a combined leave that you could just simply say, look, this is a PTO, and because of that, this is not vacation, we're going to take it all away. Now, to your question, I also think there's an opportunity to say to the employee, look, we look at half this time as vacation and half this time as HIFLA. So what we're gonna do upon termination is we're gonna give you the half that we think is vacation.
Okay.
If you earn it all as, if you use it all as vacation and you've still got 20 hours left, we're still gonna say it's 10 HIFLA, 10 vacation. I think there's an opportunity in here because of the way the very specific language in the statute is to vacation leave. Now, keep in mind, I thought this was gonna get addressed in 2021 in the legislature. I think they were waiting to see what the Supreme Court did, and of course, the Supreme Court came after the legislature term basically ended, so we may see this in the 2022 year. Keep track that this may be a changing, because it's not a great definition. But in the end, HIFLA is non-compensable, so I think pushing that in gives you more rights to do percentages, to do a full on, to do a full off.
Yeah, our concern a lot of times is how do you manage that? How do you track it? How is it understandable to all parties with the system? Because if they're well-defined, fairly simple rules, then most systems can, like for us, a payroll system, can track and measure that so the employee and the administrator can both understand what's there.
Right.
So I think that's really important as people start developing policies, that whatever it is understandable and it's not vague.
And I think that's particularly true because we're in right now a time when HIFLA applies to those 16 or more.
Right.
Now, the 16, I'm not saying there's a large employer, but it's certainly larger than those with 15 or less.
Right.
And so those with 15 or less are about to have to comply with HIFLA sick come January 1, 2022. So I think we're gonna see more combined policies in smaller organizations. And that would then need to be tracked as. But I think I've had audits that have gone before the Department of Labor on that 50-50 issue, and the Department of Labor has come back and said, you don't owe PTO, you don't owe CAL, consolidated annual leave, you don't owe anything because this is a combined, and you made clear in your policy that you don't have to pay the whole thing.
So one of my concerns on tracking is the new Colorado sick leave, the HIFLA, is it accrues at a rate that's faster, considerably faster than most PTO policies did. And, up to 40,
Right.
1 hour for every 30 hours, up to 48.
Mm-hmm.
But that may be a different accrual rate than, say, their PTO accrual rate.
Mm-hmm.
So I have been recommending to people that they separate those out because of the complexity of managing two different accrual rates in the same bucket.
Mm-hmm.
You also have your vacation policies that, and this is one of the questions, that you're vesting, so you're not even accruing until you've
Been there 90 days,
yeah,
or been there a year.
Mhm.
Right.
And if you combine HIFLA and vacation into one PTO, you are stuck with the day they start.
Mhm.
Right.
If you combine PT or vacation and HIFLA, back to John's question, you are stuck with at least 1 for 30.
Right.
And that's gonna give the employee about 70 hours if they work 2,080 hours in a year. Now, HIFLA has that cap of 48, but you also run into a problem of, well, HIFLA caps at 48. But you don't have to cap, so you could have a larger cap. So it is, I would acknowledge, it is a wonky policy when you put them both together, when you mush them.
Right.
But when you look at HIPAA and based on the Supreme Court's determination, there ain't nowhere to go with the appeal. It's not going to the
Right.
United States Supreme Court. Because it's a strictly Colorado issue. Because of that determination, if you're paying out vacation, you're paying out vacation. You
Right.
get more, so organizations who say, well, hey, my vacation accrual is only 1 for 40, I don't know if I wanna go for 1 for 30, that's a big amount of vacation. That's fine, but, or PTO, because it's combined now, that's fine, but keep in mind, you may not have to pay that upon termination.
Right.
Where if it's a 1 for 40 vacation, you are paying that upon termination. So it changes, in essence, the accounts payable of it.
Right, and because our job is systems and information management, tracking and accruals, we've been talking to people about separating the policies so that you can clearly see the two accrual balances and the two separate accrual rates, because for most companies, they do accrue at a different rate.
Yeah. You can separate them or you can put them together. HIPAA clearly allows them to be mushed together.
Right.
But HIPAA doesn't require them to be mushed together. It gives employers that discretion.
Right.
So you get some.
Enough said.
No,
So-
it's a good question. You get them all?
Well, just a point of clarification, Colorado employees are still not required to offer vacations. It's just required for HIPAA to offer the sick.
Correct.
Well, almost correct.
Okay.
You're not required to offer vacation. Colorado employers are required to offer HIPAA sick, but I would add in, Colorado employers are also required to offer HIPAA public emergency,
Mhm.
which we'll get to in a second. So don't forget, you're offering both leaves, you're not just offering the one.
Mhm.
And the definitions around HIPAA sick are pretty loose.
Oh, yeah.
It's almost, I mean, it's really, if you read the definitions, it's really a PTO policy. If I'm having a bad hair day, I can have it off. Pretty close.
I'm pretty traumatic when I have a bad hair day,
Right.
so for me, I would agree with that. Yeah, so that could be, I think where HIP was broader than normal sick leave certainly is in the definition of family member,
Right.
which is anyone the employee has responsibility for care.
Not so bad.
So it could be that friend down the block, it could be someone else who's not, would take a typical family member, so.
I think fighting somebody over taking HIPAA vacation is not worth it.
HIP was sick.
HIPAA sick is probably something that would be hard for an employer to win the argument that in almost any situation that it wasn't qualified.
Yeah, it's interesting, and these are good, because, materials man's gonna send out, so you folks, you have the materials, this is what I was hoping we'd get some real questions, the questions on these and how it works in substance, is that with HIPAA, you've got a couple, HIPAA sick in particular, you've got a couple things you need to be careful of. One, when an employee calls in, a lot of people see that, have heard, have read that statement, I can't ask for any certification in the first 4 days. Okay, you can't ask it for purposes of granting the leave, but keep in mind, employers and supervisors, you need to know the reason for the leave, because as you said, HIPAA sick is really broad. HIPAA public emergency, that ain't so broad.
Right.
And so close contact, for example, isn't covered in public emergency. Other things are not covered in public emergency. And so from that standpoint, if you have an employee come in and say, well, I'm missing time, you need to know currently, is it under HIPAA public emergency? Is it under HIPAA sick? What's it under? So we need to make sure we're defining that. Now, does that mean you're slowing down the leave? No, probably not. You still got that certification issue. Additionally, those with FMLA, don't forget you have your requirements to make sure that you're, getting the certifications for that, and that may kick in more quickly than 4 days. So you may not be able to condition HIPAA HIPAA sick based upon that certification, but you can condition FMLA on that certification. So you've got these things. And then, of course, you've got the issue that came up. I'm not suggesting anyone would possibly lie to get leave, but we had the issue recently, of course, with Country Jam coming up, behind us, where people would call in and say, oh my God, I'm so sick, I need to take HIF was sick. And there's a hummingbird outside our window listening.
Definitely.
I need to take HIF was sick. It's the droning of my voice that draws the bird. I need to take HIF was sick. And the employers are like, well, hold on a second, I gotta get some certification, because frankly, I think this person's lying. Like, I'll give them the leave, but I saw on Facebook that they were at Country Jam.
Right.
And that ain't a place you go if you're sick.
So let's talk about that. So, because there's been all these new leaves granted, it's a huge cost burden to employers. Massive cost burden. So if an employer, sees on Facebook that an employee is in fact not sick, that they're going, woo-hoo, at Country Jam, what's the employer's recourse at that point in time for the fraud?
Yeah, I think the organizations do, I always say to in organizations when I do talks, don't follow your employees on Facebook. There's nothing good that's going to come from
Right.
it. Because
I mean,
they're going to complain about the organization, they're going to complain about their supervisor, just don't follow them. But if there's a fraud issue, I don't think HIPAA jumps in and keeps an employee from termination. So I think there's a lot of follow-up questions like, okay, let's go over your sickness. When did you have it? When did you clearly get better? And walk through those issues. And if the employee is like, look, I'm gonna be honest with you, I just wanted the time off to go to Country Jam. Okay, now the employer's lied to you. That is not terminating the employee because they used HIPAA, it's terminating the employee because they lied. So organizations should ask follow-up questions to see if they can determine how truthful was that request. Now, people do get better. Oh my God, I woke up and I felt like crap, I just wasn't gonna make it. But shockingly, by noon, I was able to rally, and that's why I went to Country Jam.
So not to wear this out, but because we all follow each other on Facebook and whatnot, if an employer is friends with an employee on Facebook and it comes to light that they lied and they were at Country Jam, say, use that example, is it legal to use that as a source of information?
Mm-hmm. Okay. Yeah, it is.
Okay.
It's now, keep in mind, there's a protection for lawful off-the-job conduct.
Sure.
So you can't terminate an employee for going to Country Jam because,
absolutely,
as I understand it, I've never been, it's lawful, but who knows what goes on, so maybe it's not. But that notwithstanding, you've got the issue of that there's an exception in that statute that if the employee engages in a conflict of interest, and I think lying to the organization is. Now, I'm not saying simply because they go to Country Jam, it's a lie.
But if they're
It's something I want to follow
pay.
back up on.
Right, yeah.
So we did get another question in. So how far back prior to June would we be required to pay out vacation upon separation of employment?
Oh, that's a really good question. So like if you haven't been paying out vacation and the organization now sees Clark's and you say, hey, I guess I should have been paying out vacation, I haven't been, I don't have a PTO policy, I don't have anything combined, it's strictly vacation. The argument would go back that employees can bring a claim under this law for 2 years, not the vacation law, under the Colorado Wage Act. It's 2 years, 3 years if it's willful. It's going to be hard for someone to establish a willful penalty because none of us knew what the actual requirements were. 2 courts disagreed with the Supreme Court. So I think you'd be looking back at 2 years. Does that require the organization to do that? That's up to you. I will tell you that employees would have a claim for the 2 years, so be careful on that.
So it would be retroactive?
It could be someone, an employee could come in and say, look, apparently you didn't pay me under vacation, and that's a violation of the law. I just found out about it. I've been recently terminated within the last 2 years. I want my vacation leave payout. There's certainly an argument that it could go back.
I mean,
because the law is not new. Only the interpretation of the law is new. So they would say the law has been in since 2004. And again, you do not want a wage and hour lawsuit.
Right.
You do not want one of these lawsuits. So if you say, no, we're going to fight this for this $1,500, my response would be, you should just pay out the $1,500.
Right. I mean, this discussion is why we've always recommended to people that they separate the policies so that they don't have these arguments with employees, even though there's a convenience factor to blending PTO and vacation and having those. Because I've said to people, you know, with HIPAA, I think you should have a separate policy, that's a HIPAA policy, and a sick and if you also want to have sick or vacation in addition to that, I want to be able to point to that policy and say, we comply.
Right.
And never have this argument.
Yeah, I mean, that is, I think, I mean, that definitely makes it clear, because you would owe vacation, you wouldn't owe HIPAA. I think there's an argument you wouldn't owe PTO. But in the same light, John, we've been advising organizations, don't have a user lose on vacation, have a cap.
Right.
So when you reach the
And we've done
wall,
the same.
in that way,
Yeah.
you know what your wall is. Speaking of caps, that leads into the next question. Whether an employee can be required to forfeit leave that isn't necessarily earned, as I jokingly refer to it as the Apple leave, where we don't give you leave, you can just take it off. It's kind of unlimited vacation. I think that there's an argument under those leave that it is never earned, it's never determinable, because it's an amount that is not determined. So I think that if you have unlimited vacation, and if you do, you really need in-house counsel, because I'd love to come work for you under an unlimited vacation policy. But you, I think, are not falling under. But again, I would really encourage, if you're gonna do that, to have an unlimited PTO. That way you have even a second argument to that issue. A couple of other cases that this is not gonna be good news time. These are two cases that recently came out that basically put some organizations at potentially more liability. This first case, the Colorado Court of Appeals determined that employees can sue for missed wages, missed breaks. So, as we all know, comps changed-ish the break law in March of 2020. What the Court of Appeals ruled is, we don't think that really changed it. We think it's been an argument for a while. So, employee who sues, you're just not going back to March 2020. You're going back to whenever you started with the organization. Even though Comps 36 is the one that kind of brought that in, we're gonna say that employees, you can sue for the last 2 years. So it's not as much of an issue now. We're obviously in August 2021, so they're only going back to August 2019. But it's still a time period for beyond what comps had. The other one is the lunch issue, because we get this question all the time. This is a recent case where, the law, comps clearly provides, look, if an employee has to get 30 minutes, but if an employee doesn't get 30 minutes and the organization pays for the 30 minutes, then no harm, no foul. Well, this court came in and said, well, the law requires you to show that it was impractical for you to provide the meal period. So before we just dismiss the case, employer, we're gonna make you prove that giving the lunch was impractical. You can't just say the very short explanation of, we don't know this because we paid for the 30 minutes, you have to do this. So you have to prove it's impractical. An interesting case. I don't know if Health One is planning to appeal that, but that was an interesting case, so keep track of that. Okay, this is gonna be a quick state legislation, because here's the good news. Most of the stuff we were really, really nervous about did not come to pass. Yay! In fact, the one thing did not come to pass. That's the big thing. The gender identity expression, anti-discrimination, which is a change to the law with respect to protected classifications. The current law defines it as sexual orientations. The new law, which goes into effect in September 2021, changes it to also include gender expression, gender identity. So for those organizations that have clearly defined protected classifications in their handbook, which we always recommend, we recommend that come September, you have new definitions in your handbook for gender expression and gender identity. That is supposed to be gender identity, not gender identified. See, I knew I would find that typo after I did it on the big screen. As I told Matt, and this talk took a lot longer, so I missed one. So make sure you're including in your handbook those definitions. and September 2021 would be a good time to make that. The bill prohibits a lot of discrimination, a lot of areas, the ones, of course, we're all concerned about, because this is employment talk, is employment practices. So it becomes effective September 11th, make sure you get that in there. Another thing, and this is more of a moving money around issue, but I just wanted to let everybody know it ain't going away, is that in November, we passed Proposition 118, which gives employees paid leave starting January 1 of 2024. Employers are not permitted or not required to take any money from employees from withholdings until January of 2023, which means that the Department of Labor has no money to implement this new law. So what they did is they funded this with a $1.5 million transfer from the general fund to the FMLA program. It's not anything, this is just moving money around, but it's just one of those things that for people who always call me like, oh, that Proposition 118 is not going to happen. Yeah, it's totally going to happen. So if you think it's going away, it's just not. So we don't have to do anything yet, but we're about a year away, I would say, from changing handbooks to identify how we're going to handle at least the withdrawal of the Prop 118 money. Power is the big bill. It would have changed the definition of employees to include independent contractors and subcontractors. It would have added protected classifications. It would have really lowered the standard for hostile work environment to basically anything that the person felt undermined that they felt humiliated about, which would be an interesting way to handle a performance improvement plan. It would have expanded the definition or the time limit for filing claims. In the end, this did not pass. It is not going away. So don't sleep on this one. It's coming back in next term. It's happening. I don't know if it's going to pass, but it's definitely coming back. So don't sleep away on this one. This is a new law that actually went in 2020, but I wanted to raise it because it does give individuals greater rights, and I've already seen my first case on this, greater rights to complain about what the individual feels is the organization's, in my case I have laissez-faire attitude toward COVID. They are not happy with how the organization handled COVID or is handling COVID with the mask, and the individual was terminated shortly thereafter for what the organization claims was other reasons. But this new law, public health emergency whistleblower, they love acronyms these days, does give them a right, so keep that in mind. Those are the big new laws.
It's more like pew.
Yeah.
Pew.
Yeah, COVID, questions, and it's just never good.
We do have a question about
Okay.
FMLA. So moving backwards to the 12 weeks time the state is providing, when is that available to employees? Not for another 2 years?
Not for another 2 years, January 1, 2024. FMLA is, of course, still available, but it's unpaid leave unless you get 2 leaves together, like HIFWA and family. I mean, if you've got someone on HIFWA, there's a decent chance they're under FMLA. So you make sure as an organization, you're not just, it's like workers' comp. The question always comes up, I got an employee on workers' comp for 6 months. And I say, are they on FMLA? And they say, no, they're on workers' comp. And I always remind people, don't forget, workers' comp actually has no leave provision to it. An employee doesn't get leave under workers' comp. They get wage replacement. So an employee who is out on workers' comp leave is out on a leave that doesn't exist. If you're over 50 employees, you're going to want to put them on FMLA leave, much like HIFWA, maybe even HIFWA public emergency. It's going to cheat and say it's going to depend on each situation. So, yeah, the new Prop 118 doesn't come in for another year and a half, and then I'm taking a lot of leave. No, I'm not. A couple of questions under with COVID, so many things. Can we require employees return to work? Yes, you can. Just keep in mind, there may be some reasonable accommodations under the ADA, someone with a disability, particularly with the increase of the Delta variant. They may need accommodation request. Vulnerable individuals may look to be treated differently. Parents, those living with the vulnerable individuals also may need accommodations. Organizations really should develop a plan on how to treat workers. The most important thing I find is, what does your job description say? You know, we're getting into issues right now where employers are saying, I want employees back to work because this reason, that reason. And I always say, well, does your job description say that they have to work on the premises? And they say, nope, or a lot of times. And so if you want employees to work on the premises, this is an opportunity to amend your job description to say it's an essential function.
Manon, we lost audio again.
How long have I been talking without audio?
Try again.
How long have am I on?
You're almost there. It's just
I'm almost,
breaking up a little bit.
am I there in there now?
Oh, that sounds better.
Okay, I'll
Yep.
get closer. Usually people not say I'm not quiet. So, we were talking about, can you require employees to return to work? Yes, you can. You want to make sure your job description identifies if you think it's an essential function for employees to work on the premises. A lot of that, I don't know how we didn't see a pandemic coming. No, I'm kidding. A lot of job descriptions don't say that. And so if you want employees to be on the premises as their primary work source, as their primary work site, make sure that's identified.
So what about, from a practical perspective,
Mm-hmm.
as an employer, not every employee is suited to work from home.
Right.
And I think that there's certainly a concern from employers, a trust factor that they have to build before someone can work independently from home. Any suggestions on policies or how to communicate that?
I mean, I think, I wouldn't do a policy on that. I mean, initially, I'd want to, have in the job description, particularly if you're saying, hey, there's a trust factor. I want to see how you work before you work from home. You could do something in your job description which would say, it's essential function to work on the work site unless the organization agrees to allow the employee to work remotely. So it's something that would allow the employee to come in and say, hey, I want to work remotely. But at least initially, I would not, I mean, you could have remote work policies, but I would really encourage, if you want people, start with that essential function in the job.
Okay.
Because there's a difference, John, between, also certain employees, like I'll take the office, we have attorneys, could they work from home? Yeah, they could pretty much. I don't think they're as good. I like the group mentality, I like the group think, bouncing ideas off each other, builds camaraderie. But could they work from home? Yeah, some of the time, I think it would be fine. I'd like to see the majority of their time in the office. How about my administrative assistant who does filing? No, they have to be on the site, because you can't file you can't file a hard document off-site. So, you can have those, what I always joke with folks, don't knock lawful discrimination. So in that way, I'm discriminating, but I'm lawfully discriminating because I'm doing it based upon the position, not based upon the individual performing the job.
So in the job descriptions, you need to have that this is an on-site job. Exactly. In particular. Okay.
Mm-hmm. Do we have to require employees to wear a mask? Not yet, but what time is it? What day is it? But the CDC, the Center for Disease Control, is definitely coming out, already giving the heads up that this may happen. And frankly, the CDC's recommendation from last week was whether they're vaccinated or not, if they're in a high-risk area, high-transmission area, you should be having individuals wear a mask. Not required as of yet. For those of you who saw Governor Polis's talk yesterday, or his public, whatever, he has not gone there yet, but the day's still young. Can employers test employees? There's no question that they can test employees. In fact, I had a case on it. employee claimed a religious accommodation request, said, hey, I have a religious belief that prohibits you from testing me, and the EEOC was very supportive of in responding with no. The organization has shown that, because all the data shows, that COVID is a direct threat to individuals, and so because of that, employee with religious accommodation request, disability accommodation request, you're gonna have to find another way to do this because the employer needs to be able to test. So we can test as an organization. The next question, of course, that often gets asked is, can we mandate vaccination? And the case law and the overwhelming announcements that are coming out certainly supports mandating vaccinations. The second case identified there, Bridges versus Houston, is a case where 100 hospitals, more than 100, sued, saying, hey, I have a disability that prevents me from getting immunized, getting vaccinated, and the court threw out the lawsuit. Now, I expect that to go to the Court of Appeals. It's not time yet for them to appeal, but right now the decision is very clearly in favor of employers being able to vaccinate. As we saw, Governor Polis's announcement yesterday that all state employees are basically going to have to submit to twice-a-week testing unless they prove that they are fully vaccinated. And he's encouraging organizations to do the same thing.
We are getting some questions here. So are the mandates subject to bargaining if you have a union? Are they considered a term and condition of employment?
I'm going to cheat and say it would depend on what your collective bargaining agreement says. I represent employers, so I would say unless it's something identified in your agreement, I would argue it may be something outside of the agreement. Of course, it would depend on what your agreement says. But most management right provisions in contracts say, look, unless it's in the agreement, we get to do what we want. Now, you're hearing that differently in, for example, the NFL. The NFL has a much different management right provision because they don't have as much ability to require medical tests because of the way their agreement works. So in the end, if you are covered by an agreement, you really want to work with your attorney as to whether or not it falls under the management rights section, because I would argue that if it doesn't, you can require testing, you can require, and perhaps vaccinations as well. Again, depends on what it says.
And then how will the court balance between the mandate of vaccine and the EUA status?
EUA status.
I'm not sure what Kelly means by that.
I mean, Kelly, the question being, how do you think the court will balance? I think courts are going to be very supportive of organizations. There was an article this morning I saw on MSN that basically the Congress is not doing a particularly great job in mandating vaccinations, and so they're looking to employers to do it. And employers are seeing a benefit from requiring vaccinations. We have right now 70% in Colorado are vaccinated, and so that's lower in some areas. As for those of you who may have seen Polis's press conference yesterday, he certainly took some abuse from Mesa County, wondering what he was going to do about our county, which was interesting. So I think my approach is I think the government and I think courts are going to be very supportive of vaccinations, testing, and mask wearing, the whole thing as the pandemic continues, I think.
And that the EUA is the emergency use authorization.
Mm-hmm. Yeah, I think that's going to be, I think that they're going to continue to be very supportive of that. EEOC has been, which is shocking. If you told me that a year and a half ago that the EEOC would be supporting organizations, I would have been stunned. Can a government mandate vaccinations? Well, apparently so, or at least as of right now. You may have seen Denver Mayor Hancock has identified that the following workers will be required to get both vaccine doses by September 15th. And you think, well, it's just government employers. Then he identifies hospital workers, employees in clinical settings, long-term care employees, home health workers, employees at homeless shelters, child care, school personnel, both public and private must be vaccinated by September 15th. So the mayor has certainly thrown down the gauntlet in terms of the requirement to be vaccinated. This should be an interesting. I did want to go, this material is in here, so I want to get to something, where are we? Where is it? See, I told someone this morning, I have too many slides, I always have too many slides. The one thing I wanted to answer for sure, can employers incentivize an employee to receive the vaccination? The EEOC came out recently and said, yes, that is appropriate. You can give an employee a bonus for those who show that they've been vaccinated. If it's by a third party, you can basically give unlimited bonuses, like whatever size bonus you want to give. If you're doing it or it's by a contracted party, then can't be not so substantial. What does that mean? Heck if I know. It just can't be just hugely life-changing, I guess, so that the employee feels coerced. Yeah, I'm not sure how the EOC came up with that one. And you can offer opportunities to family members, but we cannot incentivize family members to get vaccinated. So keep that in mind. You can incentivize vaccination.
Would that bonus for a vaccine be considered non-discretionary?
That's a great question. I've been getting that a lot. I'm going to cheat. I hate wage claims. I hate wage lawsuits. I would treat it as a non-discretionary bonus, particularly if you're going to do it on the clock, then it seems like something done on the clock. But even if it's not, the amount of the bump that you'll get if you treat it as a non-discretionary bonus is going to be so minor that I would treat it as a non-discretionary bonus. I would not want to deal with that lawsuit. A couple things, and there's so much on HIPAA in your materials, but I wanted to make sure we go over the basics. There are a bunch of leaves available under this, and there's a big confusion come up thanks to the federal government doing their thing, and I wanted to make sure we address it, which is Colorado Healthy Families, HIPAA, for sick leave. If you've got 16 or more employees, you are currently covered by it. That is not supposed to say 2021. Shoot, I just saw my second typo. That's supposed to say others start on January 1, 2022. So that's probably clear from the first part of the sentence. But HIPAA sick is effective for 16 or more right now, goes into effect January 2022. Which I can't believe we're coming up on 2022, for those with less. Public emergency, you're currently covered under all. Doesn't matter if you have 2 employees, 1 employee, under 16, over 16, you are covered by public health emergency. I get the question all the time, well, we don't have to worry about public emergency anymore because of Governor Polis came out and said there isn't a public emergency. Yeah, I compared that to the marijuana issue earlier. Polis may have come out and said we don't have a public emergency anymore on COVID, but the United States Department of Health and Human Services came out a week later and said that but they just said the COVID public emergency is being continued for another 3 months. So that is in place, that public emergency is in place until October. Because of that, Colorado employers have to kick it up another month beyond that, so we're at least looking at in November that we will be covered by public emergency leave. Keep track of Polis's upcoming announcements. I'm not enough of a constitutional scholar to be able to tell you, can he reinvigorate the old one, which he just declared over? Because if he comes up with a new one, there's an argument that employees will then get an additional 2 weeks of leave because it's a new public emergency that he's declared. So I'm just speculating. If he says, I'm declaring one with respect to the Delta variant, okay, is that under the old one? Because I'm hoping he makes clear in his announcement how he wants us to treat public emergency, because even though the federal government one is going on, is there an argument that he could start a new one that would then give employees an additional amount of 2 weeks of leave. Yeah, there's certainly an argument. It depends on what the public health emergency says. But in short, right now, we are still under a public health emergency. We have to treat it that way through October, which means we have to give leave through November. FMLA is still out there, as we've been talking about. ADA, Colorado Anti-Discrimination Act, is still out there. Family First Coronavirus Response Act. This is no longer required. We are not required to provide this leave. It went away December 31st, 2020. You can still provide it. Here's where the interesting question is, and I am not going to play tax attorney, so don't ask me to, but there are tax benefits to organizations that voluntarily comply with the FFCRA. What does that mean, voluntarily comply? Because as you'll recall from 3 bullets ago, we are required to comply with public health emergency leave because we have HIPAA. So if you say, hey, employee, I'm voluntarily giving you leave under Family First, not if it's the, I don't think that's true if it's the same reason as covered by HIPAA public emergency. I think you're required to comply with that. I don't think you're voluntarily complying with FFCRA if you're forced to comply, forced to comply with HIPAA public emergency. So talk with your tax advisor about that. I'm not enough of a tax person to be able, but it's a concern to me that simply saying, hey, we did HIPAA public emergency, so we want the 80 hours forgiven. I don't know if you can do that because it's not a voluntary compliance.
See, and I thought the FFCRA ended in March of this year, and then ARPA took over with
It
those.
did. It did, but ARPA kind of took over with the same, ARPA took over with like, I still call it FFCRA.
Oh, okay, okay.
Because ARPA leave gets people
Yeah.
confused. So it really, you're right, the better phrase there would have been ARPA leave, not Family First Coronavirus Response, because Family First is done.
Mhm.
But ARPA kind of said, well, we'll let you keep doing it, but it's still, that tax benefit only comes from those voluntarily complying.
Even though the state of Colorado
Required.
required.
Because the federal government didn't know that states would rush in leave, so they wanted to make sure that every state was covered.
Okay.
And so that's why they did this. Again, I'm not enough of a tax attorney to know that. But yeah, I have, and to your point, I have the ARPA, I still refer to it as FFCRA leave
I was just
because,
making sure I wasn't.
yeah, no, you're not. As I like to joke with folks, I just don't like change. So that's why I still refer to it as FFCRA leave. All the information with respect to the new paid sick leave under this is in here. One of the big things that I did want to announce, because I only have a couple seconds left, I want to be respectful of your time. The Department of Labor, if you haven't bookmarked this page, I would. The Department of Labor about a year and a half ago came out and said, remember that administrative bulletin we've had at the ready? Well, we're going to go away from that. We're going to declare that null and void. It's over. We are now going to come out with just interpretive notices. They are fast and furious these days, so make sure you're keeping track of those interpretive notices. The two that are particularly, I think, interesting, one that just came out a month ago, which says that, I'm going to go to the very end of this, and then we'll come back, is the issue of, yeah, we are under a current public emergency. Sorry, folks, I'm having to go ahead, lots of questions.
You did have a lot of pages.
I did, but I told you, I always, because I'm afraid I'm going to run out of things to say. It's right here. Oh, wait, I missed it. Is there individual liability under HIPAA and the Colorado Wage Act? Interpretive notice just came out, 11A, that basically said, yes, individuals can sue the organization and sue the organization's owner and the managers and supervisors. What does that mean? It means they may be personally held liable and assets like personal bank accounts, real property can be seized or garnished to satisfy the liability. A interpretive notice just came out on that. So keep in mind, everyone, that when you're dealing with HIPAA issues, you may have personal liability on those. So supervisors need to make sure those issues are being addressed through HR. The other interpretive notice that I thought was particularly helpful, and I get this all the time, is people say, well, we don't have to worry about HIPAA because we have a PTO policy that covers it. I would really be surprised if that was the case. You know, back to John's point we were talking about earlier, I think your policy needs to make sure it's identifying HIPAA, not just, well, our PTO policy addresses that. I think we want to be more assertive in saying our PTO policy specifically covers HIPAA, it covers domestic violence, it covers all these things. Make sure you've got a retaliation provision in there. It's my thought, you don't want to be sued on this because, going back to John's point, was HIPAA covered under PTO? I didn't know. It didn't say anything about it in there. It didn't say HIPAA. It didn't tell me I was going to get HIPAA leave. So I'm confused. So I want PTO and I want HIPAA. The best way to address that issue is to have a policy that makes sure you meet all the requirements of HIPAA. And as I call it here, a rose by any other name. Make sure you're not just saying, yeah, our PTO policy is good enough. Make sure it goes into all these issues.
Can I
I'm
ask
over.
one more question?
Yeah, I'll sit here and ask questions all day.
Okay. So we had one that came in and I thought it was interesting. If an employer requires vaccines and there's a vaccine-related injury, is that employer responsible, or can they shirk responsibility since OSHA basically told employers to report vaccine injuries?
Yeah, I know OSHA came out and said, so my mantra has always been, for 29 years of doing this, when an organization calls me and says, should I call workers' comp for this injury? I have never told an organization no, because you do not want to lose workers' comp coverage. So, would I report the injury as a lost time accident? Yeah, I would. Because you don't want to get into that thing where workers' comp says, look, you didn't call us when Bob was missing time for the vaccination. So we're going to say we don't have to cover you anymore. I would just be better safe than sorry. Now, OSHA says you don't have to put it in your log. I appreciate OSHA's statement. I would just want to be really sure we've got coverage. So is it a work-related injury? I don't think it is. But again, I'm going to let workers' comp figure that out. I'm going to let Pinnacle figure that out and not take the chance that I'm not going to get covered. And if they tell you, stop reporting to us, we don't want to know, then I'd say, fine, click, don't have to worry about it. And I document, I called workers' comp, I called my Pinnacle rep on August 3rd, they told me stop telling them, so I'm going to stop telling them. So, okay?
Thank you.
Thank you. Thanks for the time. I'm sorry, I always do that. Why do I put so many slides? Good questions. Thanks so much, everyone, for the opportunity. Certainly, if you've got questions, feel free to reach out. I tell people, if you've got questions that you didn't get answered today, I'll be happy to answer a quick question on it, and promise I won't bill you for the time. 6, 7, 8 weeks down the road, calling me like, remember that time you told us at the seminar that you do it for, it's a limited offer, so call soon.
Thank you.
Thanks so much.
Thank you.
Yeah, it's very
Appreciate
grateful to have you come and do
Glad to
this.
help. Talk with everyone soon. Be healthy, as I always say.
Yeah.
Take care.
Thank you.